Yep. Okay, that's F.
She would have got me on contempt of court. Exhibit G, here is the police officer's oath of office. However, I understand that this act came in probably before you came into office. However, it should be similar. Did you come in before 1990?
Yes.
Well then, is that the same oath as you would have taken to the Queen?
I don't remember it off by heart, but I'm sure I've got a copy. I've got a copy of it in
For sure.
in certificate form.
Yep.
Where I've signed it.
Well,
But it looks
exactly
very very similar to the one I would have taken.
Yep. And so under that, what I say to you now is, Senior Detective David Farley, I'm putting you on your oath under God, so help me God. Now I have a contract. I have, in summary, proof that a lawful meaning of criminal coercion is in according with the Black's Law Dictionary. The Black's Law Dictionary is where all lawyers and barristers use it for court cases, so that there is the one understanding for the terms that are used in law. So, according to the Black's Law Dictionary, criminal coercion is coercion intended to restrict another person's freedom of action, taking or withholding official action, or refusing an official to take or withhold action. Federal Magistrate DMAC did write court orders, and while knowing it was her, or did not write court orders, and while knowing it was her duty to deal with all that concerns before the court, or recuse herself from the proceedings. You have evidence that she failed and refused to recuse herself from the proceedings. And Federal Magistrate DMAC, if there were alleged crimes, which was admitted by way of court order, did ignore it was Her Honour's jurisdiction to deal with all crimes, and not to ignore and not to allow a person to speak of those crimes is a crime. Federal Magistrate DMAC did not write court orders longer than a period of 12 months, and those two functions did commit a criminal act of being criminal coercion. You know and have proof that the Federal Magistrate on 2 attempts did cause myself serious harm. I am not alleging that the crimes were the court orders, as the court orders written by a Federal Magistrate is immune from prosecution. However, it proves that the Federal Magistrate had the intent to commit crimes by self-admission. You have the evidence also of a medical person where these two actions did cause serious harm. Denying natural justice and knowing there is no remedy under the law to appeal something which is never written, and knowing that it would cause serious harm where appeals were denied from even being written, a person is denied natural justice under the remedy of the law. Irrespective, a crime does exist, and you have the proof now of 2 crimes. The third crime is that the magistrate had the intent to resist arrest.
So I'm just going to take you back here. Crime 1. What's her first crime?
First crime was that she wrote the court orders knowing that she has to deal with all crime in relation to the law, and that she cannot raise a court order and ignore that crime exists and penalise that she won't have any dealings with the law to actually write that court order. That means that she has failed her oath of office, that she is now biased, and it also she has failed her oath of office in that. I'm sorry, I'll just have to look.
Which page are you looking for?
No, her oath.
This one.
No, oh, it must be this one. Sorry.
Yeah.
Where she will show no ill will. So she that I will do right to all manner of the people according to law. She failed that. Without fear or favour, and she did use favour because she decided to write court orders, ignoring the fact that there was crimes and would not allow those crimes to be spoken about in her courtroom, and write orders to the effect that she had the refusal to deal with matters that were before the court. So that provided also ill will, which she had sworn in her oath that she would not do.
So basically, so I'm just trying to call me simple, but
She's perverted the course of justice.
the first one you're saying is because she was aware other issues, other alleged crimes had occurred,
Yep.
she shouldn't have written any order.
She shouldn't have never written an order, and she should never have written an order stating that she is having the refusal.
So which was the first order that she wrote that was incorrect? You know?
That one. Oh, well, there's many, but I'm just using one because this one I can prove beyond any reasonable doubt.
So the order that she wrote on the 19th of July,
That's correct, yes.
and that's 2010. And that's when she's put the issues include matters the Minister has to say are of criminal nature, which he says he has referred to a police officer in Queensland. I have not.
Oh, also, she knows that a Queensland police officer cannot investigate federal issues, and she did not correct, and she did not care. She knew that a state police officer, that if I didn't have any proofs of those crimes, that I could, that she was off scot-free. But she also continued to state that there was crimes against that had been committed by other people, and how can she write court orders knowing that there is either biased people in that courtroom, that there's people that may lie to protect. She wouldn't allow evidence to that effect. She would not allow it to be spoken in her courtroom. She made orders to the fact that no one is to speak of crimes within her court. That it's not up to her to deal with. It's not up to her to determine. I have no interest.
Okay.
By saying that she has no interest in those crimes.
You've raised in a family law court before this justice given that you believe criminal offences have occurred by other persons within the court and nominated herself.
Yes, I have.
This submission on this date says that she does not intend to make any comment with respect to whether any offences have occurred, which means the court hasn't acknowledged that a criminal offence has occurred.
But she refuses to investigate also.
During the course of the trial by me or any other person. So she's not commenting on it. That doesn't mean she's not doing anything with it. She's just not commenting.
No, she also is saying that it's not up to her to deal with. It is up to her to deal with. She is a court, it's in her jurisdiction. If I have the evidence, well then I should be able to present that evidence in the court.
According to what you've got here and the legislation you've quoted there,
Yep.
that may well be the case. In saying that, without a law degree, there's learned persons that may have actually a set procedure somewhere where it says, no, this procedure for this is, and they may have a set format for that.
Yep.
So you're saying, I have no interest in these criminal matters, which, from your interpretation, that breaches her oath.
Yes.
The next thing is, they are not for me to determine.
That's correct.
Which
is a breach of her oath.
Which is a breach of her oath.
Yep.
From what the oath is.
Well, it's not just her oath, it's actually the crimes section 18 of the Federal Magistrates Court, Exhibit B.
So that line that's underlined, they are not for me to determine, is incorrect.
Yep.
They are not for me to prosecute.
That again is incorrect.
Which is incorrect by virtue of section 18.
Yes.
I do not intend to make any comment.
So in other words, she's remaining silent. She's refusing to remove herself after I had written an affidavit.
During the course of his submissions appeared to be making an oral application.
It wasn't just an oral application. No, I was stating that it was I have an affidavit stating that it was manifested biasness as well as apprehended biasness, and I went through a list, and I'll provide you.
You don't have that affidavit here by chance?
I do.
You do? No, that's...
Constitutional error, jurisdictional error, procedural error, denial of justice, error in fact, error in law, error in judgment, error on the face of the record, fraud, misconduct of the judge, misconduct of the independent children's lawyer, misconduct of the counsel retained misconduct of the solicitor of the first respondent, misconduct of the counsel retained for the first respondent, apprehended biasness and manifested biasness. And I did provide the proofs within that court that those actions had happened. However, transcripts have been altered. I was denied to speak of them. I was told not to speak of them, and she ordered me not to speak about any crime in her court. Now, I can't prove that, but
you can't get that order because you've been not provided any transcripts whatsoever.
Any transcripts or any order.
Okay.
But
has she given a written order that you're not to speak of them?
No.
So she's only relying on, what is it, 120 of the... what's the one we're not to disclose?
No, that's the gag legislation of 121 of the Family Law Act. But that's only to not expose lawful sanctions that happen in a court. That's not. That doesn't.
So if it's unlawful, it's if it was something that's unlawful, technically under 121, it shouldn't.
That's
that
correct.
won't be a breach.
There is no law, Dave, that would protect criminals. There is no law that is there or meant to be to protect criminals. So therefore, I am not committing a crime.
Okay, but obviously the exhibits, yes. I'm going to jump ahead a few things here because I know you've got your private prosecution going. This is the type of material that ideally this is your preparation, this is your case. In that side of things, I'm not saying that means it has to stay there because I honestly can't answer, I don't know.
Yeah.
But obviously the process now is it's either going to remedy your private prosecution or if a law agency other than the Family Law Court, Magistrates Court as per the Crime Act should be looking at, if another agency takes that on, and I'm not saying that it's the QPS, it may well, I still have a feeling that it should be the AFP looking at it because it's federal.
Okay, can I explain that?
Yep.
The AFP, you already know that Kim Dwyer is second in charge.
I didn't know what range
she is. She's second in charge for Queensland.
Yep.
McDonald, I've forgotten her surname, is first in charge. She is the most senior officer. They are friends. They are work colleagues. I can present you a recording of the Kim Dwyer advising that irrespective of me providing proof, 100% proof that transcripts were altered, that she will not indict a federal magistrate, and therefore I believe that she is complicit in a crime, and there is collusion in the fact that she refuses to provide remedy to the situation, and it has left me where I have no way of relief to having done what I have done, which is to raise the indictment myself. However, in saying so now, because of your oath, and if your oath, it does not state that it deals with state legislation or federal legislation, it's dealing with all crime, and it always has been since the year dot. And so what I am after, and I've given you the Black's Law. Now, did we go through that one, the Black's Law?
Yeah, Black's Law, Federal Magistrates did not write court orders while knowing it was her duty to deal with all concerns.
Yep, so that's the third crime.
Sorry, what's the first one is the 9th and the 7th is the first court order. What's the second?
Oh, sorry, the second is that one, sorry. Yep.